Good morning, everyone, and it gives us great pleasure to be able to present to you this morning on the Pen Safety Act. Although these proposed amendments were published a little while back, the Department of Employment and Labour has been actively putting in place new draft regulations, which I think is aimed at supporting the amendments when they are published formally in due course. And it's a very good idea to be on top of some of these proposed changes because it gives you some understanding of what will be expected of you in your respective workplaces. Now, it is so that the Occupational Health and Safety Act doesn't apply, for example, in the mining sector. But what's really interesting is these proposed amendments are speaking to the Mine Health and Safety Act and its regulations, which have been in place for some time because it's been more stringent than what we have seen under the OHSA Act. And I'm very pleased that I have some of my mining colleagues on this particular call because it's important to be able to understand these changes in context, not just what's happening in your space and industry, but also understanding the developments in case law. And a lot of important material in that regard does stem from the mining sector. So I do want to welcome our former Chief Inspector of Mines, who I know is listening into this call. Welcome, Jacques, and thank you for your attendance. The program is going to be as follows. I intend to do my introduction. I have a number of important aspects I want to cover. Importantly, the proposed changes in relation to an employer's obligations, not only towards its own employees, but third parties, because that's where much of the controversy from a litigation perspective has arisen. I will also be dealing with certain of the new definitions and how that impacts this particular subject. I'm also going to be dealing with, I want to put it as the list work issue, because I think there's an important angle there that you'll be interested in. And obviously occupational hygiene, because I feel in this space, health has been the poor cousin to safety, and we need to be able to see both on the same continuum. I will then be handing over to my associate, my senior associate, Khadisha Pashe, who's going to talk to an extremely important development where we're moving away from the concept of a health and safety policy to that of a health and safety management system. And he's going to be able to inform us from a practical angle what will be expected of employers. Because it's not just a question of having a system and then leaving that system to play out on its own. There's a lot of hard work that has to happen in order to ensure that system is operative and that it's doing its job in ensuring safety and health at the workplace. And thereafter, my associate Byron Modisa will be giving a presentation on the enforcement angle with regard to these amendments. They are important because it's introducing the new theme of an administrative fine, which is not heard of in this sector. Mining sector has been very much in tune with this. It can be extremely onerous. It can also have significant implications for an employer because you tender for work, your safety record is going to be up for scrutiny. So these are not to be taken lightly, even if it replaces the prospect of formal prosecution. It's still a significant penalty that can be imposed. So with that in mind, I intend to kick off. We do not do these presentations by way of slides. We speak to our subject matter. I think what is important, though, is that I'm sure many of you will have key questions. We will be keeping a tab on those key questions, and we will be circulating a brochure after this seminar, as we did with our amendments to COIDA recently, so that you can have access to that. So by way of a general if you like, intro to what I want to talk about, I intend to speak to the general duties of the employer, as I said, not just in relation to his or her own employees, but also that of contractors. Sorry about that. So what we know from Section 8 up until this point is that there's been a codification of the employer's duties, what's expected of the employer in relation to managing safety at work. And that has been to make sure that there is a system of work that covers plant and machinery, ensuring that it is indeed operative and can be utilized without risk, and that reasonable practicable steps can be taken to eliminate or mitigate hazard or potential hazards to the safety and health of persons before resorting to the use of personal protective equipment. And where has this change really embedded in these proposed amendments? Those general duties that we speak to are now going to be subject to the risk management plan, risk management assessments, all forming part of that risk management system that Khadisha is going to speak to. But before you can analyze that and understand it, I want to give you the case law, which has spoken to this in particular, because that, as I've said, are the duties with regard to the employer towards his own employees. But what happens when self-employed persons are in the workplace? You've brought in independent contractors, subcontractors, who don't know your environment as well as your own employees. And you will see in these amendments, it's not too dissimilar to the Act as it currently stands. The word reasonably practicable measures does not appear. Now, I want to take you to a decision not that long ago. It was handed down by Judge Tina Sawendo. I know her very well. She's a former colleague of ours and a former director of our own firm before she was called to the bench. And she gave a really important decision in Jubea versus Buscall Pty Limited. And the plaintiff in this particular matter was the deceased's wife. She was acting in her own right and on behalf of the dependents of their marriage. Her husband passed away in an accident. He was an apprentice with a company called Lyra Electrical, and they have been brought in to do specific work for Buscall. And this meant going into a particular confined space and to conduct the work. But although that was an oxygen deficient space, there was a problem because it seems he entered that space without knowledge of the hazardous vapor, dust and fumes which were present in that environment at the time. He suffered exposure to those toxic gases, etc., and passed away. And when her pleadings were first developed and drafted by her attorneys, they didn't make mention of the concept of any strict liability, and the whole decision turned on her wish to amend her pleadings to bring into focus the issue of strict liability for the death of the deceased whilst on the property of Buscall. There was no employment relationship then between the deceased and Buscall. But in order to understand what is meant by strict liability, can best be described as it holds a company like Buscall liable for injuries or damages caused as a result of their acts or omissions, even if they acted without intent or were not at fault. Now, this arises from two aspects in this decision. First, the section that deals with the employer's duties towards third parties, and noted, as I said, that it talks to they need to conduct and to ensure, as far as reasonably practical, that all persons other than those in their employment who may be directly affected by the activities are not exposed to hazards or which could impact their safety. And of course, it's got to be read with Regulation 5. She calls it Regulation 5 in the judgment. She's clearly referring to the General Machinery Regulations, that all employers or users of machinery shall take steps to ensure that a confined space is entered by an employee only once it has been tested and has been found to be safe, so that the person who's going to work there can do their work in safety. Now, she looked into this, and I said to you, this wording of reasonably practicable is of interest to us. This is what she said on the issue of strict liability, because obviously Buscor opposed the amendment because it didn't want to be faced with that additional stricture in terms of it defending this dependence claim. And she said, in my view, the effect is that that section 9.1, read with that GMR regulation, have not only imposed a duty of care on the employer, they have also hardwired the standard of care. In this regard, the liability of an employer flows directly from the recognised unlawful act under a statute, being the breach of that duty, as well as the breach of the prescribed standard imposed by the OHSA. Now, that tells you that that's an onerous scenario if the employer is going to defeat a claim of this nature, because they would have to show, in order to exculpate themselves from liability, that it had met the prescribed standard, statutory standard, by demonstrating the actual measures taken to prevent or mitigate the safety risk or the hazard created. And the amendments to the pleadings were allowed. We do not know, obviously, the outcome of the case on its merits. It's obviously of interest to us all, but it could even have been a piece of litigation that settled. But the important point here is you can be held to a standard which is extremely onerous, and being able to turn around and say, I wasn't at fault and I wasn't negligent, isn't enough. And that is why it's going to be so important to ensure that you're not facing those sort of civil claims from third parties. Because obviously you'll know from my talk on COIDA recently that Section 35 of COIDA prevents an employee from maintaining a claim of this nature against an employer by virtue of the fact that they get compensation under COIDA for any injury or if there's death, it's a dependence claim if that is suffered. But that Section 35 in COIDA doesn't protect you from claims by third parties. And that gave rise to the debate that we had last time we were together. Well, what does in course and scope of employment mean? An incident arising out of employment in order to determine whether that Section 35 bar to a civil claim under COIDA exists or not, or should be applied or not. Now, in another decision I want to refer to, and this one is slightly different. It's the one of Clements versus Milberg paper. Here, the employee, because this issue of course and scope came up in this case as well, but there's an angle to it which is extremely important, and that is Mr. Clements was working on machinery. He'd locked out that machinery. He'd done everything that he needed to do. And he suffered severe injuries at work when he was performing his duties. And what happened was hot, molten adhesive blew up onto his face, his hands, his abdomen, badly injured. And the cause he asserted was that 3 of the employer's senior management were under the influence of alcohol when this accident occurred. And what they did is they walked past this piece of machinery that had been locked out, disabled the lockout system, it started operating, and this chap Clements is caught in that particular problem and hence the injuries caused to him. Now, that case did turn on whether Section 35 of COIDA would have application, because those of you familiar with it will know that the deemed employer definition includes a senior manager with the power to hire or fire, the CEO, a person in charge of machinery, an engineer. Now, that tells you that if they're negligent, then there's no claim against them if Section 35 bar includes them as part of the grouping of an employer protected from a civil claim. In this instance, what Clemens was saying was, I'm going beyond that Section 35 bar because these persons were grossly at fault in causing my accident. I want to sue them in their personal capacity for the damages that I have sustained. And of course, those three individuals said, no. This deemed employer definition shields me from being sued civilly for those damages sustained by Clemens. And the judge had to deal with this case on the basis of an exception because it was raised by the individual defendants, the senior management crew, that there was no cause of action against them. Clemens would be able to claim from the compensation fund. But, said the judge, he had what he called an incongruity. He said consideration needs to be given to this incongruity, identified, i.e., you've got senior management who are acting in a completely reckless fashion. They shouldn't have been on the property under the influence of alcohol, and they shouldn't have been tampering with equipment. And why should they be protected from a claim and raise the Section 35 bar if the incident hadn't been caused by persons at that senior level? It had been any other employee, Clemens may have been able to sue them directly because the bar would not have applied. And interesting what the judge said. He said, I'm not going to allow this exception because these questions need to be asked by a trial court after considering all the evidence that needs to be tendered. So what I think is important is this is an area we've got to be careful of going forward with the amendments, particularly via the strict liability concept, because as I've said, where its origins arise, and it's not a new concept in our law because it's something that has always existed in relation to the maintenance of public safety or the protection of the environment. So those of you who are understanding the National Environmental Management Act will know that there is strict liability that is presented therein. The question for consideration is how far does that strict liability go? And I think interpretation of those amendments to the OHSA Act down the line are going to assist us. But you can see why some of the amendments are being proposed, because it's taking into account the sort of case law that our High Court has been grappling with. On the issue of listed work, and we want to understand what that means, it's work which poses a risk to health and safety, which requires specific precautionary measures to be implemented. And up until this point, it has been the Minister of Employment and Labour that will issue a gazette which will stipulate what is that listed work and what that entails. But the important point here is that listed work is a special protected category of work. But before the Minister can now implement that, he would be required to invite interested and affected parties to make representations should they wish to do so. And there's a specific period within which those comments must be permitted, i.e. 3 months. And I think that's going to be very helpful so that one can understand that if we are impacted by any issue relative to listed work, that we understand its implications, because it's going to go back to your safety management system, and it's also going to go back to issues relative to liability. Now, the definition of danger in the Occupational Health and Safety Amendments is of interest to us all because this definition broadens the scope beyond what we have been used to, i.e., an event causing injury, death, because it's now going to include an event that could cause adverse health effects, not just damage to persons' property or injury sustained by them. Now, there is examples that we can think of immediately giving rise to this change in the definition, because we had that outbreak of listeriosis at a manufacturing plant in Polokwane. We had the COVID-19 pandemic. And not far from our thinking at the moment is, of course, the issue that we have with Mpox. Those of you who were listening to the Bongani Bingwa on 702 this morning would have heard that the World Health Organization is looking at introducing strictures on this particular health risk because there's a new virus that has been detected, which is way more virulent and dangerous than its predecessor. And that's a great concern in terms of how it is starting to manifest in countries beyond just those where it was initially picked up. In other words, it's spreading. And where we are seeing this front of mind in the OHSA amendments is to look at the definition of the occupational medical practitioner and the new definition that has been proposed, that of occupational hygienist. Now, at the moment, the Department of Employment and Labour has only had about 600 inspectors serving our different sectors, mining sector aside. They have recently announced that they have introduced another 100 inspectors who will be looking specifically at occupational hygiene. And I think that's important. We have clients at the moment who are under audit for various aspects relative to hygiene and issues of that nature at the workplace. And I think it's showing to you that the department, although it has always been top of mind for them, it's just now an opportunity to put greater emphasis on health at the workplace, as I indicated in my introduction. Now, I don't want to run over time, and I see that I'm happily doing just that. So I would like to hand over to my colleague, Khadishu, to take you into the detail of such management system. Thank you very much. Thanks, Khadishu.
Thank you, Fiona. Thank you for such a detailed introduction and giving us context of where we currently are and what these proposed amendments seek to introduce into our law. And again, as Fiona said, my name is Khudisho Pashe, and I'm a senior associate in the Employment and Occupational Health and Safety team at Cliff Hoffmeyer. I'll be discussing an important component of the proposed amendment, specifically the safety management system, which will also share the name as the health and safety management system. Now, the proposed amendment aims to replace the current Section 7 of the Occupational Health and Safety Act, which deals with the health and safety policy. Now, before we explore the details of this amendment, I think it'll be prudent for us to first discuss what the definition of the safety management system is. What is it exactly that they're proposing? What is it that they want the health and safety policy to be replaced by? Now, the safety management system, or the health and safety management system, is defined as a coordinated or comprehensive set of interrelated or interacting elements to establish occupational health and safety, occupational health and safety objectives in order to optimally manage health and safety in the workplace. Like, in summary, all this means is that there are a set of elements which will be working together to promote or manage the health and safety in your organization or in your place of work. So it's essentially, what systems are you as an employer putting in place to manage occupational health and safety? So it goes further than just beyond having a policy that is drafted, but it looks at what systems are entrenched within your business processes and how those actually play out. Now, going back to this section 7, the proposed amendment states that the chief inspector may direct an employer or a group of employees in writing to develop and implement a health and safety management system. Now, previously, or rather, as things are right now, it states that the chief inspector may direct a category of employers or categories of employers in writing by notice in the Gazette to implement a health and safety policy. And as I've said, the proposed amendment seeks to change that, whereas again, it removes the requirement of notifying employers through a Gazette. It just says may direct employers or a group of employers to develop and implement a health and safety management system. Right now, what exactly does this system entail? The amendments give us guidelines as to how the system is to be dealt with, right? So we're not left by ourselves or on our own to figure out exactly what it is. The new proposed Section 7.2 states that this system that we've been discussing right now, shall be accompanied by guidelines concerning the contents of such a system. So in essence, when the chief inspector directs employers or group of employers to implement a certain health and safety system, that direction or that notice will be accompanied by guidelines concerning the contents of exactly what this health and safety management system will look like. So rest assured, we will receive some guidance in that regard, and employers will be held to a standard of things that were communicated to them. Now, and an interesting fact, just as a passing note, is that the new proposed amendments introduce an omission. As you would know, previously employers were required to permanently display a copy of their health and safety policy, which was signed by the CEO. And this health and safety policy was to be displayed where employers report for duty. Now, this has been removed, or rather, the proposed amendment seeks to remove this aspect, as the focus is now on developing a comprehensive system rather than merely a policy. However, I would like to emphasize that in no way is it saying that you need to do away with your current health and safety policies or scrap any other measures that you may have. All it is saying is that it's putting a requirement of what this new system is. It's not merely a policy, but a system that is integrated within your business processes. Now, moving on to duties, because as an employer, you're probably thinking, well, whose duty is it to implement and develop such a health and safety management system? Now, as we know, Section 16 of the Occupational Health and Safety Act charges the CEO with certain duties. And one of those duties in the proposed amendments is the duty to develop and implement this management system. And again, I would like to emphasize those two components: the duty to develop and implement such a management system. It even goes further than just these two aspects, which are the starting point of it all. But it says that the chief executive officer shall develop, implement, and continuously review the health and safety management system. Right. Now, as we can hear from the wording of this, it is ultimately the CEO's responsibility, the chief executive officer's responsibility. Obviously, we are aware that the CEO, as a Section 16(1) appointee, may assign any duties to any person under his or her control, which person shall act subject to the control of the CEO in the interest of occupational health and safety. It is very important to now note that currently the CEO is not necessarily required to put assignments of duties in writing as per the Occupational Health and Safety Act as it is. Although many employers do so in practice, we also recommend that as it is a good practice. However, under the proposed amendments, any assignment done by the chief executive officer must be done in writing, right? So any further assigning of duties must be done in writing. Furthermore, these amendments add that should a person who's also delegated by the CEO be in charge of developing or implementing such a health and safety management system, such a person may not delegate that duty to any other person. So the duty to implement, to develop, to continuously review this health and safety system will lie with the CEO or the person that the CEO assigns such a duty to, and that person cannot delegate it further. Now, that is very important as it restricts or rather limits the amount of persons who are responsible for accountability purposes. And we think that this is a move in the right direction. Now, I'd also like to look at a very crucial aspect of this, which is the health and safety committees, right? The amendment proposed changes to Section 19(3), which governs health and safety committees, or rather adds that to the aspect of health and safety committees. Now, thinking about these management systems, to develop and continuously update such a system, you'll definitely need the support of the health and safety committees. Now, the proposed Section 19(3) clarifies that the role and purpose of these committees is to ensure the efficient and effective operation of the health and safety management system. Now, another crucial aspect which I'd like to just look at, which Fiona did touch on this, and it goes back to the general duties of employers that are housed in Section 8. I want to look at the issue of the risk assessment because I think it's a very important aspect when trying to develop your health and safety management system. You need to understand what exactly are the risks that my place of work is faced with. Now, there's a proposed change to these general duties that I'm referring to. Employers are required to conduct a work-specific risk assessment. Right? Now, following this, employers must develop and implement a written risk assessment plan. So firstly, you need to come and do a work-specific risk assessment. And then from that specific risk assessment, you need to have a written risk assessment plan of how you're planning to address each of those identified risks. Now, I would like to to just put this in your mind is that when you're thinking of this risk assessment as an employer, you shouldn't think of it as a broad or a blanket risk assessment which applies to your entire workplace. However, it should be workplace specific. And workplace specific means that you should be thinking about areas or a place where your employees perform work. And where your employees perform different types of work in different areas, then you should have different risk assessments which are applicable to those different areas. So obviously, a risk assessment that is applicable to persons working in an office will vary to a risk assessment of persons who are working in a boiler house or in some sort of industrial area where there's machinery. So that's what is now required of employers, to conduct risk assessments that are specific to the different types of workplaces and not just generally. And this is going to be very important, as we'll see. It should be linked clearly with your health and safety management system, right? And again, this amendment is crucial for effective safety management systems, as this risk assessment process will need to be integrated into your business process, as I said previously. Now, I'd like to just spend a few minutes just looking at what are some of the practical implications, or what are some of these aspects of this health and safety system that we may need to be aware of. Again, with this, just keep at the back of your mind that the minister will issue guidelines, right? The minister, excuse me, the chief inspector will issue guidelines as to the contents of the health and safety management system. However, it's good for us just to think about exactly what have we seen in terms of certain international standards regarding a health and management safety system. So I'll just try and go through a few which you should be aware of, right? We expect that some of these guidelines that may be direction or that may accompany such direction from the chief inspector may reference certain international standards such as the ISOs, and one ISO in particular which is very helpful in this regard is the ISO 45001. And this is an international standard that provides a framework for organizations of any size, activity, or location to manage and continuously improve the occupational health and safety practices, right? Now, this ISO that I just mentioned is similar to the management structure outlined by the ILO, the International Labour Organization's guidance on occupational health and safety systems. Now, if we think about it, by adopting a systematic approach that includes worker participations, organizations can integrate their occupational health and safety systems into their business process as a core business function. So think of it not just as a mere policy, but as a core business function that you need for your business to thrive. So that is how it's meant to look at, not just as a document that is laying there, but as a system that you are actually running on a continual basis, right? Now, I'd just like to look at a few things that would be helpful for employers to incorporate into such a health and management safety system. And again, the first one that I'm going to speak about now is one that I've already referred to before, and which is the risk-based thinking. Again, I would like to re-emphasize this. Employers need to adopt risk-based thinking, right? This is the central tenet of the ISO 45000, and it requires the management team to continuously assess the issues that affect occupational health and safety aspects of organizations, right? And to target specific problem areas. Again, look at specific areas that are prone to risks and have a risk-based thinking approach. Another measure which would be helpful in such a system are walk-through audits, right? Now, again, this is trying to move us from just having a policy that is housed somewhere to a system which is implemented on a day-by-day basis, right? Now, a less formal approach, in addition to your usual audits that you would do or your statutory inspections, is walk-through audits, right? Now, this may be conducted by senior leadership or at occupational level to inspect areas of the organization to predetermined statuses or standards. Now, again, this is an opportunity to engage with workers and to actually find out exactly what are some of the risks or what are some of the issues that they have on the ground as persons who work in that workplace on a daily basis, right? And through these walk-through audits, you'll be able to enter into a different stage of hazard identification. Now, obviously, hazard identification is fundamental in the planning process to prioritize actions and to address risks and to further find opportunities for better safety. So when you conduct these walk-through audits, you'll be able to identify hazards and you'll be able to think about how you can manage those better. A further aspect to consider is the management of change. Now, what do I mean by management of change? Now, whenever you have processes or systems or just practices that deviate from defined or regular measures, you may have issues. So like it is recognized that accidents can occur when there's a change in terms of controls, machinery, or technology that may come into place, right? Now, this also includes when you have changes in competent supervision and workers are introduced to materials, new processes, and new machinery. When you have these changes and there's no system in place to manage these changes or to inform employers or to educate employees about these changes, you may be prone to accidents, right? Now, how does this relate to this health and safety management system? You as an employer in your organization, you must define and implement a process which considers change throughout the business, right? Now, this may come in the form of a written policy which accounts for different scenarios based on the risks that accompany the different changes. So should there be changes in competent supervision or in machinery, then you should ensure that there's a system that is implemented to manage that change in order to avoid accidents. Another factor that I would like us to consider is conducting due diligences on your contractors. Now, again, this will be very important as contractors assist employers a lot, and many businesses use the services of contractors to fulfill gaps in processes and to complete tasks requiring specialist knowledge. Now, it would be very beneficial for employers to conduct due diligence competency checks. And you should have specific criteria for your contractors to ensure that their services are firstly within scope, right, of the scope of the task, and there are safety measures in place. Because again, as Fiona mentioned, there are certain consequences that come with having injuries and accidents in the workplace as an employer. Now, you as an employer must be satisfied that there's a process to protect your workers who may be exposed to hazards due to the activities, whether within your place of work or within the place where contractors may be involved. And this makes you to think about this earlier on during the procurement process, where you're thinking of certain processes to implement, certain written agreements, what is important, your section 37(2) agreements to protect yourself should be established between your organization and the contractor. Now, I'd just like to just close off this section by just mentioning one other measure, which or rather aspect, which I think you should consider in your health and safety system, and it's the aspect of leadership, right? And how leadership can be demonstrated within the occupational health and safety management system. And this is something that you as an employee you need to think about. You need leaders to take overall responsibility and accountability for the prevention of work-related injuries, as well as the provision of a safe and healthy work environment. Now, this will provide a positive culture and continual improvement, because when you have leaders that are fully bought into this system and not just see it as a policy, this will ensure that your system, again, and I'll keep on repeating this, is integrated within your business process. It's not just the standalone division or standalone aspect, but something that is integrated, and safety is kept in the highest standard. Now, with this, I'd just like to hand over to my colleague, Mr. Baran Madisa, who will deal with the issues of non-compliance enforcement and how the proposed amendments change our landscape, or our legal landscape, in this regard. Thank you, Baran.
Thank you very much, Khudiso, and good morning, everyone joining us online this morning. So I first want to deal with the issue relating to the jurisdiction of the Labour Court in relation to OHSA-related issues, right? And with this, I want to deal with the case that went to the Labour Court. It's the Public Servant Association on behalf of members versus the Minister of Health and others. Now, this is an important case because it clearly identifies or tells us the current position in relation to the jurisdiction of the Labour Court. So what happened in this case was that the Public Servant Association, which was representing its members who were employed by the Department of Health in the Civic Center in Pretoria, the Civitas building, they initiated proceedings in the Labour Court in terms of Section 1581B of the Labour Relations Act. And they sought a number of reliefs, and among them, they sought a relief that would direct the Minister of Health, as well as the Department of Health, the Minister of Public Works, as well as the Department of Public Works, in terms of Section 8 of the OHSA Act, to provide, as far as reasonably practicable, a working environment that was safe and without risk to the health of those employees who were employed by the Department of Health. They also sought a direction that the respondents should comply with a recommendation that had come out in a report that was conducted by the National Institute of Occupational Health. They also sought an order which would direct the respondents to move these employees from that building into a safer working environment. And lastly, they sought an order directing that their refusal to work in this building, which was unsafe, should not be interpreted as a strike. Now, when the matter came before the Labour Court, the court immediately raised the issue of jurisdiction and whether, in terms of Section 157 of the Labour Relations Act, either the Labour Relations Act or any other law conferred jurisdiction on the Labour Court to grant this relief that was sought. The court held that, obviously, when you look at the provisions of the Occupational Health and Safety Act, the Labour Court only enjoyed appellate jurisdiction, and there was no express provision in that act or any other act for that matter that conferred jurisdiction to hear matters that related to the enforcement of general obligations, such as the ones contained in Section 8 of the OHSA Act. Now, what the court then did was that it stood the matter down to allow the parties to address this issue of jurisdiction by filing heads of arguments. Now, in so doing, the Minister of Public Works and the Department of Public Works raised an important or an interesting point, which was that there was no employment relationship between the Department of Public Works and these employees. Because if you recall, I said these were employees employed by the Department of Health. So the Department of Public Works and the minister said, well, there is no employer relationship here as contemplated by Section 8. Therefore, the court does not have jurisdiction to then entertain this claim insofar as it relates to the Minister of Public Works and the department. Now, what was the finding of the court on this issue of jurisdiction? Turning to Section 157 of the Labour Relations Act, the court held that the employees who were not aggrieved by a decision of the chief inspector, all right, the relief that they were seeking related to the enforcement of those general obligations or general duties of the employer found in Section 8 of the OHSA Act, which were read in this case with the recommendations that were made in that report by the National Institute for Occupational Health. The court therefore had to decide whether this is a matter in terms of which either the Labour Relations Act or any other act, specifically the OHSA Act, was to be decided by the Labour Court. The court pointed out it's important that when you look at the Act, the OHSA Act, specifically Section 35(3), which was the one that confers jurisdiction of the Labour Court, it only confers jurisdiction to the Labour Court as an appellant court, not when it is sitting as a court of first instance, right? And the Labour Court found that there was no other provision which conferred general jurisdiction to the Labour Court. It pointed out, therefore, that the Labour Court had no inherent jurisdiction, right, except for those matters which were referred to in Section 151 sub 2, which relates to matters under the jurisdiction of the Labour Court. The court therefore found that it had no jurisdiction as a court of first instance in relation to the enforcement of these obligations under the OHSA Act, right? It therefore found that when you look at Section 1581B of the Labour Relations Act, it could not be interpreted to mean that in the absence of any other provisions in the Labour Relations Act or any other law which conferred jurisdiction on the Labour Court, the court may nonetheless compel compliance with the provisions of the Labour Relations Act. The court found that when you look at the wording as well as the purpose of this section, it did not confer jurisdiction on the Labour Court. It was merely an empowering provision rather than a source of jurisdiction. The court therefore found that it lacked jurisdiction to grant any of the relief that was sought by the employees. And on the jurisdictional point that had been raised by the Minister of Public Works, the court upheld this jurisdictional objection because it found that there was no employment relationship and therefore there was or could not be any obligations that flow from Section 8 of this OHSA Act. Now, another case, and it's a recent case, which confirmed this lack of jurisdiction by the Labour Court in relation to OHSA issues is the case of OHSA versus Anglo-American Platinum and others. The judgment was issued in May this year. The court held there that unlike Section 82 of the Mine Health and Safety Act, which confers exclusive jurisdiction on the Labour Court to determine any dispute about the interpretation or application of that act, when you look at the OHSA Act, it did not have a similar empowering provision. Therefore, Sections 157 and 158 did not confer jurisdiction to the Labour Court. Now, let's look at the important amendments, the proposed amendments, and if they'll have an impact on the jurisdiction of the Labour Court. Now, the expected changes, right, to this position is that now we'll see that in terms of these proposed amendments, the jurisdiction of the Labour Court has actually been extended in relation to occupational health and safety issues, right? If you look at the proposed Section 46(1), now the Labour Court will have jurisdiction to determine particular disputes about the interpretation or application of any provision of the OHSA Act, except where the acts provide otherwise. However, there's an important limitation to this jurisdiction because if you look at the proposed Section 46(2), it then says the Labour Court has no jurisdiction in respect of the offences in terms of this Act. Now, when one looks at this proposed amendment, it seems as though it's borrowed from that Section 82 of the Mine Health and Safety Act, because it has a similar reading, right? So this is obviously an interesting and welcome development. However, in terms of how it's going to play out in practice, it remains to be seen, because you know that this jurisdiction, the High Court has the same jurisdiction as well. So the decision will now be whether to still go to the High Court, which has always been the case, or following these amendments would now more people go to the Labour Court, even though the Labour Court still has no jurisdiction in respect of offences in terms of this Act. So it might just be that you'll only be able to go to the Labour Court in limited circumstances. And if you're then dealing with issues that might require or relate to offences in terms of the Act, you then still then have to go to the High Court. And one last issue, I see that we're almost out of time, that I would briefly want to touch on is the one that Fiona mentioned in her introduction, the issue of administrative fines. Right now, when we look at the proposed changes, all right, Section 73A, its introduction to administrative fines, reads that if a person commits a breach of this Act, the inspector may, by written notice to that person, impose an administrative fine in accordance with Schedule 2. Now, when we look at Schedule 2, you see that for those administrative fines, they go up to 50,000. Now, Fiona already mentioned that this is an important development, right? And it's important specifically for employers to ensure that they comply with the provisions of the Act to ensure that these administrative fines are not imposed, right? And my reading of these administrative fines is that because there's a listed sections there, there's an issue of those fines when the inspector writes to you that notice, it's in relation to a specific contravention, right? So it's kept at 50,000. However, it's not for all your infractions from the reading and when you look at Schedule 2. Because if it's a contravention of Section 7 of the Act, for example, that is kept at 50,000. But what happens if, in addition to that, there's a contravention of another provision of the Act? There's a maximum fine for that breach as well. So it is clear that these administrative fines for non-complying employers specifically could pose a serious problem. So it is important under those circumstances to ensure that at all times you are complying with the provisions of the Act. And that is where I'm going to leave it. I'm just going to hand back to Fiona to give a few words in closing.
Thank you very much to my team for their presentations as well. As I said at the introduction, this is an important area that we need to keep our eyes firmly on. There's not going to be any one right answer necessarily, because it's going to certainly depend on what form the amendments finally take when the Amendment Act is published. There have been a number of comments in the chat group, notably from one of our colleagues. I see from Richard Spoor, Inc. Hello to you, George, and I'll be responding to your questions shortly in writing. I'd rather do it that way. As I said, we'll be sharing our document, which will be a summary of today's discussion, which will be available in due course. And I'd like to thank you all for attending. We did go over our time limit a little bit, but I think it was warranted. Thank you very much indeed.